the takeaway is this. In any situation where you're accused of personal use of a firearm in a felony case, you could be facing a lot more time than you think you might be looking at for the charges that you're originally facing. Hi everyone, Attorney Joe McPeak with Virtuoso Criminal and DUI Lawyers. Today, I'm going to be talking about a sentencing enhancement, and this is an enhancement that we see in a lot of the cases that we defend, the personal use of a firearm enhancement. This enhancement is governed under California Penal Code section 12022.5. It applies to any situation where the defendant is alleged to have personally used a firearm in the commission of a felony offense. Under this Penal Code section, if you're convicted of committing a felony offense while also personally using a firearm in the commission, you could be facing an extra 3, 4, or 10 years of state prison. 3, 4, or 10 years. That's a lot more time tacked onto whatever additional time you might be facing based on the underlying charge. Now, there is a little bit of a safety valve here. The enhancement says that it does not apply to any situations where the use of the firearm is an element of the underlying offense. Unfortunately, however, a charge where this often comes up, this exception also still does not apply. So, for example, you might be thinking an assault with a firearm under California Penal Code section 245A2. Well, that can't be made more serious with a personal use of a firearm enhancement because use of a firearm is already an element of that offense. Unfortunately, the personal use of a firearm enhancement says, yeah, while this does not apply to situations where a firearm is an element of the offense, it still applies to assault with a firearm under Penal Code 245A2. So the assault with a firearm statute already contains a huge upgrade to the amount of time that you could be facing based on not only the prison sentence you can get for that, but also the prison sentence of additional 3, 4, or 10 years based on that enhancement alone. It's a type of double counting that is often, avoided, but the legislature has explicitly authorized in the context of assault with a firearm cases. So in other words, if you're trying to defend a case where you're alleged to have personal use of a firearm, you and your lawyer have to be aware of this situation where you could be facing a lot more time potentially if the case is not defended correctly. If a case like a 422 criminal threats could become more serious if during that instance you also allegedly used, maybe just brandished or displayed a firearm in the course of whatever threats you allegedly made. And that's not counting the fact that, maybe that's also a potential assault with a firearm type of situation under Penal Code 245, where there's more time coming up over there. And by personal use, we don't mean that the defendant has to have actually fired the gun. No, they just have to have personally used it in the commission. So even in cases where the defendant is to have maybe, say, used the gun as, say, a club, the same exposure applies to additional 3, 4, or 10 years potentially. It covers a broad array of conduct which is considered personal use, and that's why this enhancement is so dangerous and so serious to anybody who is potentially facing it. But there is hope. First of all, you and your lawyer could negotiate a situation where maybe you admit the enhancement, but you don't actually get sentenced on it. Or maybe there's an argument that even though your case technically does cover all of the elements where the personal use of a firearm is actually met by the letter of the law, the judge should still use their discretion to maybe strike that enhancement in the interest of justice under their power under Penal Code section 1385. Not all personal use of a firearm situations are created equal. Using a gun to perhaps maybe bludgeon or even just lightly tap somebody or just as a display of power may not always be the same as a situation where the gun is actually fired, for example. And under what context is it being used? Is it a calculated, robbery or ambush, like some sort of calculated attack of the alleged victim? Or is it a situation where maybe it's a heated exchange and maybe a gun is just displayed and therefore used for the purposes of the enhancement? Not all scenarios governed by the statute are created equal, and you and your lawyer should talk about that when trying to negotiate and argue your case if you are facing that enhancement, or even if you're just concerned that that enhancement might be added, because maybe it's a situation where that enhancement might apply, but the DA's office just hasn't added it yet. And what position does that put you and your lawyer in? And you and your lawyer have to approach that with the utmost care when defending that type of charge. Is there a way to minimize the time that carries with it? Is there a way to distinguish your alleged personal use of a firearm from others so that you're maybe facing lower time or maybe not prison time at all? These are all situations that need to be discussed and researched accurately. And that is the big takeaway from here. Serious charges demand a serious amount of attention. And that's especially the case with the personal use of a firearm enhancement under Penal Code section 12022.5.